Imagine this. The government sues your company for lying to investors. You fight, you lose. A court finds you knowingly issued false statements. Later, private investors sue you for the same misconduct. You say, new case, new chance. But the Supreme Court says, nay, you already had your day in court. That's Parklane Hosiery Co, 1979. And this is 99rights_online. So let's get into it. Here's what happened. The SEC sued Parklane Hosiery for issuing a false and misleading proxy statement. After a full trial, the court found Parklane knowingly lied. Then, private shareholders filed their own lawsuit. Instead of proving everything, they said. Parklane already litigated this and lost. They shouldn't get a second shot. The court agreed. The Supreme Court agreed, but added a fairness check. Courts should not allow this if it would be unfair, like when. The first case was tiny, and the stakes were low, or new plaintiffs wait and see, instead of joining earlier. The court used a legal tool we call defensive non-mutual collateral estoppel, a mouthful that means issue preclusion, which basically is just, once an issue has been fully litigated and decided in one case, the losing party can't fight that same issue again in a later case. What this means is, if a defendant fully litigated an issue in a previous case and lost that issue and the court's decision was final and fair, a new plaintiff, who wasn't in the first case, can use that old loss against the defendant in the new case. But the defendant doesn't get a second chance to fight the same issue. We got the Parklane principle from this case. The Supreme Court said this is allowed as long as it's fair, and especially when the defendant had a full and fair opportunity to litigate the issue the first time. The defendant knew the stakes. The defendant lost, letting them re-argue. Would be wasteful and unfair socially and economically. Parklane saves time and money, stops repeat litigation, and strengthens enforcement, especially in securities and consumer fraud cases. Today, Parklane shapes everything from investor suits to mass fraud cases. It empowers victims to build on government wins, promotes consistency, and pressures defendants to take the first case seriously, because that loss can echo for years. If you're a company facing regulators, remember, the record you make in case #1 might decide every case after it. So, in short, if you lost the issue once, you don't get a do-over just because a new plaintiff shows up. Thanks for sticking with us. If this helped you survive another civil procedure rabbit hole, like, subscribe, and follow 99rights_online for more legal quickies.